in terms of what we're doing. So I don't want to cut off that. So what I thought we would do is see if General Counsel Shanklin can get through both of her presentations, then we take lunch, and then take questions about all the case law concerning mandatory bar associations after lunch. And then after lunch, of course, we'll finish up our agenda for the day. So if you're ready, General Counsel Shanklin, we're ready to learn.
Okay, thank you. Okay, so I can start off by saying this is not intended to be everything about every case. This is not exhaustive. It's a broad overview of some of the First Amendment cases relating to integrated bars. It's split up into two time periods, which probably won't make any sense, but 1956 is kind of the beginning. 2014 is just before Janus, and then the second is Janus up to where we are now. So next slide. So this is just a short reminder of the terminology that we use. Voluntary bar associations are voluntary memberships, so no compelled fees, and they don't administer regulatory functions. There are mandatory bar associations that do have compelled fees and membership, and they may or may not administer regulatory functions, and integrated bar associations that are mandatory membership, and they do integrate the two areas of functions, the regulatory functions and what are termed professional association functions. And as Doug Ende mentioned earlier, the first mandatory integrated bar was created around 1921. And typically the numbers associated with the different types of models, and I can't remember if Doug Ende mentioned it, but even in the pleadings so far that I've seen, the numbers they talk about for integrated bars are potentially 31, and then this agency model, as Doug Ende referred to it, about 20. So next slide. I have given this presentation before and said, I know it seems weird, but the history of the First Amendment litigation and cases about bar associations has to do with trains and mushrooms. So we're going to start off with trains. We'll get to the mushrooms in a little bit. So mandatory bars started in about 1921. And then in 1956, there's this case about it's a Railway Act case. So employees sued the railway companies and the unions, asking for an injunction preventing enforcement of a union shop agreement that would require, it was in a statute, that would require all of the employees as a condition of employment to join and maintain union membership. That statute had previously prohibited union shop agreements, but now it was going to allow them. And the statute specifically said that it was going to allow these union shop agreements, notwithstanding the laws of any state. So the claim here was that it violated the state right to work provisions or the provisions of the Nebraska state constitution. And the unions argued that their regulatory role for all employees justified the union shop. So already, I'm sure all of you have been paying attention to the case law that we have. So already in 1956, we hear the same issues as we're hearing today, at least some of them. And then also I find it interesting to note that here Congress changed the law. So they changed the Railway Act based on changes in the world. Originally, employers' unions were being used to prevent collective bargaining rights. But then company unions started to disappear, And then as high as 80% of the employees belonged to the unions. And then the problem became non-members were receiving collective, non-union members were receiving collective bargaining benefits and not paying. So again, we're echoing things then and now. So the holding in that case was really based on the Commerce Clause. You can see on the slide, we hold only that the requirements for financial support of the collective bargaining agency, blah, blah, blah. And then you get down to the First Amendment holding, did not violate the First Amendment. Okay, that's it. That's actually the whole of the First Amendment analysis, except for the very bottom bullet on the slide. On the present record, there is no more an infringement or impairment of First Amendment rights than there would be in the case of a lawyer who by state law is required to be a member of an integrated bar. Why is that here? I have no idea. Here it is. So the entirety of the First Amendment analysis in this case is that sort of 1.5 sentences. I will point out that this was a request for an injunction. So this was before the act had taken effect. And so the compulsory membership hadn't really occurred yet. So they couldn't really, there wasn't any evidence to show what the actual impairment might be. So there's a sentence in the case that says, it's argued that compulsory membership will be used to impair freedom of expression, but the problem is not presented by the record. And that's just because it hadn't happened yet. So the next slide. So then in 1961, there are 2 cases decided on the same day. One of them is a bar association case, and one of them is, again, a railway case. They are presented as being related cases. In this particular case, and I haven't mentioned, sorry, but in the materials, all the sites of these cases, I didn't put the sites on the slides, but there is a document that has all the citations for the cases. So here in Street, the union members alleged that the dues required by the union shop agreement was being used to finance candidates for state and federal office that the members don't support, and to promote the propagation of political and economic doctrines, concepts, and ideologies with which they disagree. In the Superior Court, they actually issued an injunction finding a violation. The Supreme Court, though, didn't decide the case on constitutional grounds. Instead, it just construed the statute to be constitutional, just saying it is to be construed to deny the unions over the employee's objection the power to use his exacted funds to support political causes which he opposes. Now, in Justice Black's concurrence in Street, he ties this case to Lathrop and says that he would have found a First Amendment violation here. It says the constitutional questions raised alike in this case and in Lathrop are bound to come back here soon on a record so meticulously perfect that the court cannot escape deciding it. I would therefore hold that the Railway Labor Act, in authorizing application of the union shop contract to the named protesting employees, violates the freedom of speech guarantee of the First Amendment. So again, the cases are definitely related. Next slide. So that's not the next slide. That went backwards instead of forwards. Yes. Yay, okay. All right, so the companion case to Street, Lathrop versus Donahue. The Wisconsin bar was integrated in 1957 for a 2-year trial period. And then 1 year later in 1958, it was continued, the integration was continued indefinitely. in this case was brought as a challenge. Members brought it as a challenge to the 1959 dues. And it says in the complaint, I do not like to be coerced to support an organization which is authorized and directed to engage in political and propaganda activities. The complaint goes on in a little bit more detail to allege that the state bar promotes law reform and makes and opposes proposals for changes in laws and constitutional provisions, and argues to legislative bodies and their committees and to the lawyers and to the people with respect to the adoption of changes in codes, laws, and constitutional provisions. In the course of this activity, the State Bar of Wisconsin has used its employees' property and funds in active, unsolicited opposition to the adoption of legislation by the legislature of the state of Wisconsin, which the plaintiff favored. And it says, all contrary to plaintiff's convictions and beliefs. So the circuit court actually dismissed that case, and the state Supreme Court affirmed the decision. So the US Supreme Court stated that the core of appellant's arguments is that he cannot constitutionally be compelled to join and give support to an organization which has among its functions the expression of opinion on legislative matters, and which utilizes its property function and employees for the purpose of influencing legislation and public opinion toward legislation. So the court said that the issue was compelled financial support of group activities, a claim of impingement upon freedom of association, no different from that decided in Hansen. And it makes clear here that freedom of association in this case is defined as compelled financial support for a group whose activities can include speech. So that definition, I think, is important for where we're going to go. I would say after lunch, but maybe before lunch, later on in the story. There's a couple of things that are interesting in this case. So let me jump to the end. So the holding, we are persuaded, we are persuaded on this record that we, I'm getting myself all out of order. I can't read the slides, so I'm having a little bit of a problem. So the first bullet, we think that the Supreme Court of Wisconsin, in order to further the state's legitimate interest in raising the quality of professional services, may constitutionally, it's not the whole, may constitutionally require that the costs of improving the profession in this fashion should be shared by the subjects and beneficiaries of the regulatory program, the lawyers, even though the organization created to attain the objective also engages in some legislative activity. So the reason I wanted to read that quote is to connect back to Doug Enday's presentation and point out that, the idea of who's paying for the regulation just keeps coming up. And then, given the character of the integrated bar shown on this record in the light of the limitation of the membership requirement to the compulsory payment of reasonable annual dues, we are unable to find any impingement upon protected rights of association. So they're focused on the association right here, again, is limited to payment of fees. You can see there that there isn't really any explicit level of scrutiny going on. It looks like the court may be heading towards something that looks like trying to figure out, is there a compelling government interest here? And, is this least restrictive means? But it's not explicit and it's not really there. And then the bottom here, we therefore We are persuaded on this record that we have no sound basis for deciding appellant's constitutional claims insofar as it rests on the assertion of his rights of free speech, whether that's violated by the use of his money or causes, which he opposes. So Lathrop versus Donahue had and has stood for the proposition that integrated bars do not, can exist, can constitutionally exist, and they do not violate right of association. But this case specifically did not decide the speech issue. A couple of other things about Lathrop. First, it was a plurality opinion. And secondly, so Justice Douglas was the justice who put the sentence in Hansen about integrated state bars. And in his dissent in Lathrop, he said, in the Hansen case, we said to be sure that if a lawyer could be required to join an integrated bar, an employee could be compelled to join a union shop. But on reflection, the analogy fails. So again, that is going to be a theme that's going to be echoed, I think, throughout all this time. Is there, should case law between unions and union shops be the same as the case law that controls integrated bars? Justice Douglas seemed to have started that off, and then he at least abandoned it. Next slide. 30 years later, Keller, our favorite case. So you can see right away, Keller was in 1990. The GR-12 that we have was in 1987. So, the language that we have in GR-12 isn't exactly like the language that we'll discuss in a moment in Keller, which makes sense because our court adopted our court rule slightly before the Keller decision came out. So, as I said, Lathrop was a plurality opinion. Keller's a unanimous opinion. In Keller, members of the bar sued, claiming that the use of their membership dues to finance certain ideological or political activities to which they were opposed violated their rights under the First Amendment. And Doug Enday talked about some of this, but the trial court granted summary judgment for the state bar. The California Court of Appeals reversed based on Abood, the 1977 U.S. Supreme Court decision that talked about that union activities and dues could be financed only if the actions in question serve the state interests important enough to overcome First Amendment rights. And then the California Supreme Court reversed on the grounds that the state bar is a state agency, and as such, it may use the dues for any purpose within its broad statutory authority. And then the U.S. Supreme Court agreed in part. It agreed that lawyers admitted to practice in the state may be required to join and pay dues to the state bar, but it disagreed as to the scope of permissible dues-financed activities that the state bar may engage in. So I want to go backwards just a little bit, just for a moment. So when we get later to some of the cert petitions that are pending right now before the Supreme Court, they are arguing specifically about the broadness or narrowness of the holding of Keller. And some of those arguments are specifically focusing on this idea that the California Supreme Court reversed and had held that the state bar is a state agency, and therefore basically the First Amendment doesn't impact this. And so then when the US Supreme Court made its decision that therefore the only thing that was necessary to the decision was to decide whether the state bar was a state agency or not. So you'll see that later. But again, I just want to highlight that as we walk through all this. So in Keller, they referred back to Hansen and Lathrop and said, surely those two cases laid to rest all doubt that a state may constitutionally condition the right to practice law upon membership in an integrated bar association. But Keller, of course, excuse me, there's messages flying around. Is there something I need to know about this? Okay. So, sorry, lost my train of thought again. So Keller did raise the free speech issues that were not decided in Lathrop. So it did address the use of petitioners' compulsory dues to finance political and ideological activities of the state bar with which they disagree. And there was some reliance on Abood. And it's very interesting now because the amount of reliance interest that there is on Abood and Keller is also one of the things that is really being discussed and litigated now. So one of the things that the court said in Keller was it noted that several federal and state courts had applied the Abood analysis in the context of the First Amendment challenges to integrated bar associations. It specifically found also that the state bar was not a part of general government, and instead it found a substantial analogy with employee unions. So we're back to that now. The State Bar of California was created, the U.S. Supreme Court said, not to participate in the general government of the state, but to provide specialized professional advice to those with the ultimate responsibility of governing the legal profession. There is, by contrast, a substantial analogy between the relationship of the state bar and its members on the one hand, and the relationship of employee unions and their members on the other. It is entirely appropriate that all of the lawyers who derive benefit from the unique status of being among those admitted to practice before the courts should be called upon to pay a fair share of the costs of the professional involvement in this effort. So Abood was certainly used to craft, or it appears that the court used the Abood standard to craft the standard for integrated bars. So Abood held that a union could not expend a dissenting individual's dues for ideological activities not germane to the purpose for which compelled association was justified. In Abood, was a teachers union case, that was collective bargaining. Here, the compelled association and integrated bar are justified, the court said, by the state's interest in regulating the legal profession and improving the quality of legal services. Thus, the guiding standard must be whether the challenged expenditures are necessarily or reasonably incurred for the purpose of regulating the legal profession or improving the quality of legal services available to people of the state. And Keller referred back to the Lathrop opinion for that, the plurality opinion. So then when we get to the bottom of this, we find the state bar may therefore constitutionally fund activities germane to those goals out of the mandatory dues of all members. It may not, however, in such manner fund activities of an ideological nature which fall outside of those areas of activity. That quote shows up a lot in the cert petitions that are sitting before the court right now, and we'll get to the different ways in which that is being interpreted. But the court goes on in Keller. The difficult question, of course, is to define the latter class of activities. And the standard that Keller gave us to work with, precisely where the line falls between those state bar activities in which the officials and members of the bar are acting essentially as professional advisors to those ultimately charged with the regulation of the legal profession on the one hand, and those activities having political or ideological coloration, which are not reasonably related to the advancement of such goals on the other, will not always be easy to discern. But the extreme ends of the spectrum are clear. Compulsory dues may not be expended to endorse or advance gun control or nuclear weapons freeze initiatives. At the other end of the spectrum, petitioners have no valid constitutional objection to their compulsory dues being spent for activities connected with disciplining members of the bar or proposing ethics codes for the profession. So, then it's important also to focus a little bit, sorry, I'm really having a hard time reading my slides, on the last bullet. Petitioner's complaint also requested an injunction prohibiting the state bar from using its name to advance political and ideological causes or beliefs. This request appears to implicate a much broader freedom of association claim than was at issue in Lathrop. The California courts did not address this claim, and we declined to do so in the first instance. So, as you know, if you jump forward, there's a lot of focus on that right now. There's a lot of focus on what did Lathrop leave open? What did Keller leave open? What is it that exists that the US Supreme Court has not yet decided? And that's been the focus of a lot of the recent cases. Okay, next slide. In 1999, the Ninth Circuit decided Morrow versus State Bar of California. This is not a US Supreme Court case. This is a Ninth Circuit case, but since we're in the Ninth Circuit, we tend to pay attention to the Ninth Circuit cases. Again, this was plaintiffs complaining about how the state bar was spending their mandatory dues. They were seeking a refund of the proportion of their dues that had been spent on political activities. And here, you can see how it appears that the broader freedom of association claim was addressed. The court said the issue is whether plaintiffs' First Amendment rights are violated by their compulsory membership in a state bar association that conducts political activities beyond those for which mandatory financial support is justified. Plaintiffs contend that language in Keller leaves open the question whether membership alone may cause the public to identify plaintiffs with state bar positions in violation of plaintiffs' First Amendment rights. And then the court said the claim reserved in Keller was a broader claim of violation of associational rights than was at issue in either Lathrop or this case. Here, the plaintiffs do not allege that they are compelled to associate in any way with the California State Bar's political activities. They do not allege that the bar's political involvement is greater and that the regulatory function less than it was when the court decided Keller and Lathrop. Lathrop controls our decision here. So there's the Morrow decision shows up a little bit in Crow. So I wanted to make sure that we covered that. Next slide. Okay, we've made it to the mushrooms. So this case is, there was a federal statute that created a mushroom council, and it imposed mandatory assessments on fresh mushroom handlers to fund product advertising. And there was a large agricultural business that grew and distributed a lot of different products, including mushrooms. And they didn't want to pay just to claim that, you know, all mushrooms are great. They wanted to advertise that only their mushrooms were great. And so they sued. And the question crafted by the court was whether the government may underwrite and sponsor speech with a certain viewpoint using special subsidies exacted from a designated class of persons, some of whom object to the idea being advanced. And the court clearly stated here that the level of scrutiny required for these First Amendment issues, and they cited both Abood and Keller here, was exacting scrutiny. And they, compulsory subsidies there. Oops. And so the reason that I'm citing the mushroom case is just to make clear that at least in 2001, we are clear that the correct standard, or the court is telling us the standard they're going to use in First Amendment cases about compelled financial support for speech is exacting scrutiny. And you can see serving compelling state interests that cannot be achieved through means less restrictive of associational freedoms. And then importantly, and the fees are necessary incident of the larger regulatory purpose which justified the required association. So you might think back to when we were just discussing Keller, whether Keller has that standard in it. Next slide. So the next two cases are cases both authored by Justice Alito, increasingly being critical of Abood. And so that's why these two cases were in this first part, and then Janice began the next part. But they also have a lot to say about Keller. So Knox is a teachers union case, and it talks about the union sent the required employee notice of agency fees, including the percentage that would be chargeable. The notice did say that the fee could be subject to increase at any time without further notice. And during this time, then a bunch of ballot measures became important, and the ballot measures that related to the union and public employees' salaries. And so the union decided to join a coalition of public unions opposing these ballot measures. So they sent a notice increase of the agency fee, sort of on an emergency temporary increase to their members, but they didn't provide any new opt-out period. And so petitioners objected to that. And the decision was that when public sector unions impose a special assessment or a dues increase, the union does have to provide a fresh notice, and it cannot exact funds from non-members without their affirmative consent. They reversed the Ninth Circuit on that, and the case was remanded for further proceedings. And maybe I've skipped a step here. So the fees, these agency fees that they're talking about here, when in a public union, you're not required to join the union. You were, at this point in time, required to still pay an agency fee because you were getting benefits from the union. So in this case, again, in Knox, the court specifically said, we made it clear in the United Foods case that compulsory subsidies for private speech are subject to exacting First Amendment scrutiny and cannot be sustained unless the two criteria are met. First, there must be a comprehensive regulatory scheme involving a mandated association among those who are required to pay. Such situations are exceedingly rare because as the court has stated, mandatory associations are permissible only when they serve compelling state interests that cannot be achieved through means significantly less restrictive of associational freedoms. So again, they're pointing out that exacting scrutiny is going to be used in these situations. Justice Alito, in this opinion, started really questioning the free rider justification that's pretty prominent in Abood. The primary purpose of permitting unions to collect fees from non-members, we have said, is to prevent non-members from free riding on the union's efforts, sharing the employment benefits obtained by the union's collective bargaining without sharing in the costs. But then the court goes on to say, but such free rider arguments are generally insufficient to overcome First Amendment objections. And the court began calling Abood an anomaly. Acceptance of the free rider argument as a justification for compelling non-members to pay a portion of union dues represents something of an anomaly. And then they say an anomaly that we have found to be justified by the interests in furthering labor peace, but an anomaly just the same. In the next case, Harris versus Quinn. So this case again is continued questioning Abood. But this case is very interesting, I think, for our analysis. Because in this case, the court, this is a case about extending the Abood. Here, this state law allowed people to hire personal assistants that were needed to provide home health care. And the people who needed the care actually hired, fired, trained, and disciplined these individuals, but they were paid by the state. And then they were eventually required to join this labor union. And so the question was really about extending Abood and the requirement that these people, even if they were not members, if they decided not to join the union, did they have to pay the agency fee? Could you extend that idea to people who weren't even really full state employees? They were only state employees for purposes of this particular, of joining this union. The district court had dismissed the case. The Seventh Circuit affirmed based on Abood. And again, the court talks about Abood as something of an anomaly. Free rider analysis really isn't going to be enough to overcome. But the importance of this case, I think, for us really is about the next slide, I suppose. Is it here? Yeah. So I think it's important to point out that this is a case in which the US Supreme Court is declining to extend the Abood analysis any further. But at the same time, it's talking about and reaffirming Keller. So in Keller, we held that members of a bar could not be required to pay the portion of the bar dues used for political purposes, but they could be required to pay the portion of the dues used for activities connected with proposing ethical codes and disciplining bar members. Keller fits comfortably with Harris. So Keller fits comfortably with a case that is declining to extend Abood. Keller upheld compelled fees serving the state's interests in regulating the legal profession and improving the quality of legal services. And again, we're back to the payment. States have a strong interest in allocating expenses of ensuring attorneys adhere to ethical practices and that members of the bar, rather than the general public, oh, nice that it stopped, pay for those. Thus, our decision in this case is wholly consistent with our holding in Keller. There's a dissent in Harris, and that's joined by 3 additional justices, and they all actually defend Abood. Okay, this is the end of this PowerPoint because that was supposed to be lunch. And so if you'll go to the next one. Okay, so next slide, which we probably don't need. But my idea was you would have, wait, you can go back just for a second. So the point here was if you forgot the first part during lunch, but it does sort of serve to just say, you know, before Janus, here's where we were, right? Integrated bar associations were constitutional. They did not violate members' right of free association. In part because here in Lathrop, they held because the association was limited to funding group private expressive activities. And then Keller, you know, sort of made the speech part constitutional, so long as members only have to fund germane activities. But there was this thing here that they did not address the broader free association claim at all. Okay, now on to Janus. So Janus overruled Abood. I'm going to take a little bit of time to walk through Janus just a little bit. So it's another of the agency fee and public employment cases. And so, you know, if you have a collective bargaining exclusive representative, then that person speaks for you. And you are required, or you were required to pay the agency fee, even if you didn't join the union. The agency fee is the portion of the membership fee attributable to activities that are germane to the union's collective bargaining duties. In this opinion, Abood was explicitly overruled. Keller wasn't mentioned, except in the dissent. And that's in part why I spent a little bit of time earlier in the Harris opinion, just pointing out what we talked about there. So in Janus, this was a lawsuit initially filed by the governor of Illinois. Mr. Janus and two other employees moved to intervene because they believed the union's behavior in bargaining does not appreciate the current fiscal crisis in Illinois and does not reflect Mr. Janus's best interests or the interests of Illinois citizens. The governor was dismissed as lacking standing at the district level, and the employees were then allowed to file their own complaint. The case proceeded on the new complaint. The district court dismissed based on Abood. The Seventh Circuit affirmed the dismissal. Janus asked the U.S. Supreme Court to review and specifically asked the court to overrule Abood and to hold that public sector agency fees were unconstitutional. The court granted cert, and I'm going to read to you the first two paragraphs of the decision because they're impressive. Under Illinois law, public employees are forced to subsidize a union even if they choose not to join and strongly object to the positions the union takes in collective bargaining and related activities. We conclude that this arrangement violates the free speech rights of non-members by compelling them to subsidize private speech on matters of substantial public concern. We upheld a similar law in Abood, and we recognize the importance of following precedents unless there are strong reasons for not doing so. But there are very strong reasons in this case. Fundamental free speech rights are at stake. Abood was poorly reasoned. It has led to practical problems and abuse. It is inconsistent with other First Amendment cases and has been undermined by more recent decisions. Developments since Abood was handed down have shed new light on the issues of agency fees, and no reliance interests on the part of public sector unions are sufficient to justify the perpetuation of the free speech violations that Abood has countenanced for the past 41 years. Abood is therefore overruled. Okay, well, there's not much question about what they feel about Abood. So again, there was this discussion of the appropriate level of First Amendment scrutiny, and here the question really was, is exacting high enough? And the court said, well, we don't have to really talk about that here because it doesn't satisfy even exacting. It talked about Knox, it talked about Harris a bit. But in the end, yeah, we find it unnecessary to decide the issue of strict scrutiny because the Illinois scheme cannot survive under even the more permissive standards, which were exacting scrutiny applied in Knox and Harris. And again, I think it's clear, exacting scrutiny. And the reason I keep talking about exacting scrutiny is that as we jump forward, there are a lot of questions about, is exacting scrutiny the standard for bar associations, or is it the germaneness standard that's in Keller? So exacting scrutiny means a compelled subsidy must serve a compelling state interest that cannot be achieved through means significantly less restrictive of associational freedoms, just to make sure we're all on the same page. There was a dissent in Janus that defended Abood a little bit. We reviewed these decisions not a decade ago. This court unanimously called the Abood rule a general First Amendment principle. And indeed, the court has relied on that rule in deciding cases involving compelled speech subsidies outside the labor sphere. Cases today's decisions do not question. All right. Let me just make sure I can see my slides. Okay, so the next slide. We've already talked about that. We can skip on. So after Janus, now I know this is like super tiny and you can't really see it. And we're going to talk about many of these cases now. But the point of this slide was just that after the Janus decision in 2018, there were integrated bar cases filed in each of these circuits. And so this is why I think there's been so much attention paid to all of these questions. Are we required to change something? Is something going to change in the future that requires us to change something? Does it mean we should be rethinking anyway what our structure is? So, and as you heard in Doug Ende's presentation, some bar associations did change their structures before or after this time period. So one of the first cases that, at least in my mind, you could sort of look around and almost see a panic was Fleck versus Wedge. So I think the next slide. Yeah, so it had this very interesting procedural history. So the Eighth Circuit affirmed the dismissal of the 3 claims in the case, and the 3 claims are on the next slide. We'll skip to that in just a minute. But that happened before Janus. And then Janus happens, and then there's a request for cert, and the U.S. Supreme Court grants it. It vacates the judgment, remands it for further consideration in light of Janus. And then the Eighth Circuit issues another decision, and it doesn't change its decision. You know, it essentially says that, you know, Janus doesn't doesn't change it for us. And then it goes back up to the US Supreme Court again on a cert petition, and the court denied that petition. Next slide. So this again was a member complaint that compelled fees were being used to support legislation. This was actually a specific piece of legislation that this particular member had spent his own time and money in his life supporting, opposing, and then he found that the Bar Association was using compelled fees to support it, and he was not happy. And so part of the reason that the court, this case I think is procedurally difficult, but Fleck did have a freedom of association claim, but it wasn't considered because he at the lower court had said that he agreed that Keller controlled that claim. And so there was no record developed on it. And so then the court couldn't really do much with that issue. The court did say, though, the Eighth Circuit, Janus did not overrule Keller. And so they were reviewing the opt-out in Keller, the issue in Keller about whether members have to opt out or opt in. And since Keller was not overruled by Janus, the court just found that there was no reason to change. Next slide. So I guess all that panic and then didn't end up with much. And in 2019, there was the State Bar of Wisconsin case, Jarchow. Again, members were complaining that compelled fees violate First Amendment. They primarily relied on Janus, and the procedural history is there. At the district court level, both sides agreed that Keller was still binding, and so the court granted the bar's motion to dismiss. There's a very short Seventh Circuit summary affirmance, and the US Supreme Court denied cert, but there was a written dissent. Next slide. That is probably important. Petitioner's First Amendment challenge to Wisconsin's integrated bar arrangement is foreclosed by Keller. That's what the court found. I would grant cert to address this important question. Our decision to overrule Abood casts significant doubt on Keller. The opinion in Keller rests almost entirely on the framework of Abood. Now that Abood is no longer good law, there's effectively nothing left supporting our decision in Keller. If the rule in Keller is to survive, it would have to be on the basis of new reasons that are consistent with Janus. So this was Justice Thomas's dissent that was joined by Justice Gorsuch. So this makes its way into a lot of the current challenges, pointing out that there are at least two justices who have, in writing, stated that they believe that Keller should be revisited. They don't say exactly what should happen with it. Next slide. Okay, now we're up to the cases that essentially are in 2021. Three of these cases are pending on petitions for cert at the Supreme Court now. It does not include this one. So there were two cases, Crow and Gruber, two different cases versus the Oregon State Bar, but Crow, in April 2018, I think probably most of you remember, the Oregon State Bar Bulletin published two statements, and they were on either side of the fold of one of the pages in the bulletin. And they were relating to the normalization of violence relating to white nationalism, specifically in the Portland area, much of it. One statement was actually attributed to the Oregon State Bar and signed by the bar leaders. The other statement was a joint statement by many of the it says Oregon specialty bars. I believe they call them affinity bars now. The affinity bar statement included references to President Trump and was a bit more controversial with a lot of people. The Crow opinion actually includes the full language of both statements. So if you go and look at the opinion, you can see exactly what was said. The Oregon State Bar both said that, listen, all of these statements are germane to our role in improving the quality of legal services of the state. And they also provided a $1.15 refund to members who complained about the statement. That was their calculation of the each member's percentage of the amount that it took to produce those statements. Next slide. The plaintiffs in the case alleged that the two statements in the bulletin, neither one were germane. They alleged that compelling them to join and maintain membership in a bar association that published such statement violated their rights to freedom of association, compelling them to pay annual membership fees without prior affirmative consent, that's the opt-in, opt-out, violated their right to freedom of speech. Gruber only claimed that Oregon State Bar's Keller procedures were deficient, and Crow only claimed that the Oregon State Bar was not entitled to sovereign immunity from suit. Next slide. And again, this is just the procedural history. So the case was referred to a magistrate who recommended granting Oregon State Bar's motion to dismiss and denying Gruber's motion for partial summary judgment. The district court adopted the magistrate's decision and dismissed the cases. Both plaintiffs appealed and their cases were consolidated for hearing at the Ninth Circuit, which is why I always end up talking about Crow when it's actually Crow and Gruber. The next slide. So in February 2021, the Ninth Circuit issued a decision that said Keller has plainly not been overruled. Plaintiffs claimed that requiring membership in Oregon State Bar to practice law violated their freedom of association under the First and 14th Amendments because the Oregon State Bar engaged in non-germane political activities such as publishing the 2 pages in the bulletin. And here's the important part. Plaintiffs raise an issue that neither the Supreme Court nor we have ever addressed: whether the First Amendment tolerates mandatory membership itself, independent of compelled financial support in an integrated bar that engages in non-germane political activities. In concluding that precedent foreclosed this claim, the district court erred. Next slide. So plaintiff's freedom of association claim is viable. Because the district court erred in dismissing the claim, we reverse and remand. On remand, the district court will need to determine, 1, whether Janus supplies the appropriate standard for plaintiff's free association claim, and if so, whether the Oregon State Bar can satisfy its exacting scrutiny standard. And given that we've never addressed such a broad free association claim, the district court will also need to determine whether Keller's instructions with regards to germaneness and procedurally adequate safeguards are even relevant to the free association inquiry. So, you know, we've sort of walked through, I think, a lot of this, but, you know, it seems here that the Ninth Circuit at least recognized that there can be a claim that almost is sort of sitting between Lathrop and Keller, right? It's not in Lathrop because Lathrop found constitutional freedom of association based on financial support. This is broader than that. This is not based on financial support. And then it falls in that statement at the bottom of Keller that's talking about a broader free association claim that they didn't address. So this is why we started to pay attention when the Crow decision came out, because this is the first court decision that recognized this broader free association claim, and it's in our circuit. It's in the Ninth Circuit. Next slide. So this case went up on a petition for cert to the U.S. Supreme Court, and that was denied in October of 2021. So, you know, I can't speculate at all why cert is granted or denied, but one of the things in Crow is that, you know, the court remanded on one of the First Amendment issues, and so the record below on some of the issues that might be important wasn't completely developed. And so these statements here are pulled from the cert petition because one of the things I think you might be interested in is what are the arguments that bar associations or people who are suing bar associations members, what are they making to the court? How are they trying to ask that the U.S. Supreme Court take their case? And so here in the Crow petition, they said Keller holds that public employees and lawyers regulated under state law are subject to the same constitutional rule. So we'll see that again in some of the cases that are still pending. The argument is being made, as I understand it, that because in Keller, the specific thing that the court was asked to overrule, or that the court did change, was the just below court's determination that the California State Bar was basically a government agency. And so they're trying, the argument is being made that the only piece of Keller that is the holding is simply the statement that public employee unions and lawyers have to be, the lawyers that are regulated under state law are subject to the same constitutional rule. Forget all of that stuff about abode and germaneness, nobody cares. Like that, this is just the holding. And then they go on to say, and Janus made it very explicit that it's exacting scrutiny. And so the rule that both need to be regulated under has changed. So, you know, you need to recognize that. It will be interesting, I think, to see how that argument holds up, especially given Harris, where Harris talked about, this is the US Supreme Court's decision in Harris, talking about their own holding in Keller, and they did not describe it as narrowly as this. They described it much broader and including the germaneness standard. Next slide. So in June of 2021, the 10th Circuit decided the Shell case. And again, they found Keller as binding, but they made statements about it being vulnerable to reversal. They talked specifically about both legislative positions that the Oklahoma Bar had taken and also their bar publications. And it's very difficult for me to actually understand all of their analysis on these, but they said articles on court structure are germane. Articles about big money in judicial elections and increasing the abilities of prisoners to sue prisons may not be germane. They didn't talk a lot about a standard, but that's what they said in their decision. And then they said, listen, courts really ought to analyze everything a bar does, even if they're not all listed in the actual complaint. You know, it needs to be clear whether the bar activities are germane or not germane, and also how much non-germane activity is required for a viable claim. Next slide. So this is one of the cases that is currently sitting before the U.S. Supreme Court on a cert petition. And I don't have the exact date, but this petition was filed. The bar did not initially file a response. The court did ask for a response, and the response is due in February. One of the responses is due like February 7th, and the other is like February 28th, and I just forget which one is which. But if you look in the cert petition, again, they're saying Keller's holding is limited to just saying that bar associations and union compelled fees are subject to the same constitutional rule. You know, Janus specifically said that constitutional rule is exacting scrutiny. The statements in Keller's decision relating to germaneness are all dicta. So, and all I'm saying is that is the argument that they're making in their cert petition. Oklahoma has not filed a response yet, so I'm not able to tell you what the responses will be. Next slide. In 2021, the Fifth Circuit issued the McDonald versus Longley case. So at issue here were all of the activities of the bar. The Fifth Circuit actually decided that compelled membership in the bar, in a bar engaged in any non-germane activities fails exacting scrutiny. So their decision says, you know, the U.S. Supreme Court has not decided this issue, and they were citing to Crow for that as well. And then they said, well, the U.S. Supreme Court hasn't decided it, so we have to decide it, and we decide that compelled membership in a bar that engages in any non-germane activity fails exacting scrutiny. Less restrictive means, including direct regulation or hybrid models, exist. They pointed to the 20 agency model states that you heard earlier. They call California a hybrid model. I think this decision is the first time I had seen that. I don't know exactly what they mean by hybrid model. I could speculate, but that's probably a bad idea. Then they actually talked about Keller's germaneness test and how it would be interpreted. You know, they said Keller talked about you can only engage in germane activities, but they didn't really give a test. They just said it would be hard to determine. So the McDonald case talked about advocating substantive law changes. So an integrated bar association advocating substantive law changes is only germane when it relates to state court functioning or laws governing lawyers acting as lawyers. Any other time, advocating substantive law changes would be not germane. That's the Fifth Circuit rule. They made it very clear that section speech is bar speech when compelled fees are used. Next slide. They walked through the CLE activities and they said, you know, yep, there are things in the CLE, in CLE presentations that sure, people might not all agree with, but you need a disclaimer saying this isn't the bar endorsing any expressed view. These are educational. And we have a large and varied catalog of CLE presentations that present many, many views for purposes of education. They found that to be germane. Diversity, they said the diversity functions of the Texas bar are germane when they are, because they are regulating the profession by creating a fair and equitable legal profession for historically underrepresented groups. They said unanimity isn't required. And they said the ideological nature can be germane under the Keller test, which is different from some of the other decisions.
although they said that might be questionable under Janus. Access to justice functions, they said that aiding access to legal services is germane. Advocating substantive law changes to assist low-income Texas residents is not germane. And so I'm assuming here that this is interesting to me a little bit, because I think what they're saying, they're going back to that place in Keller where it's saying bar associations are not part of general government. I'm assuming that's at least in part where they're getting this standard. Next slide. The cert petition in this case is also pending. And again, I can't remember if the response is Monday or the 28th. It's one or the other. So if you go to the cert petition that's been filed by the plaintiff in the case, Keller does not permit compelled support of political or ideological activities, even if they relate to legal services or legal profession. So their petition actually includes the language from Keller, and their interpretation of it is that basically you can never require or compel support for political or ideological activities. Activities of an ideological nature will always fall outside the areas that Keller felt permissible. And they say that this is supported by Harris's description of Keller. And I think what they mean, they're pointing to that language in Harris that talks about that the bar can engage in the regulatory functions. I'm not sure that's what that language was intended for, but that's how it's being used here. Next slide. The Fifth Circuit also issued a decision in July of 2021, Boudreaux. This was the Louisiana State Bar Association. And again, they said Boudreaux did present the free association claim that was decided in McDonald, the Fifth Circuit other case. I think these were decided on the same day. Hudson procedures are constitutional prerequisite to collections of mandatory dues. So this actually creates a circuit split with the Ninth Circuit on the Hudson procedures. And of course, that's one of the things that you'll want to keep your eye on is where are the circuit splits starting to develop. And they also said that inability to identify non-germane activity is in itself an injury. So they were talking about the need for notification and explanation by bar associations to members about what they have done and how they are using the compelled license fees so that members can tell whether their fees have been used for germane activity or not. Next slide. I think we're going to make it before lunch. All right, I think this is the last case. So the Sixth Circuit case is, to me, maybe the most interesting or unique one. So all of the parties in this case agreed that all of the bar's activities were germane. There's a very long and detailed set of agreed facts that this case is using and proceeding with. And the decision finds that Lathrop and Keller are binding precedent despite Janus, and that integrated state bars limiting their activities to germane activities using the Keller test to determine that are constitutional. Next slide. So this case too is pending on a cert petition before the court. And I will say that I've heard from people they can't find this case. If you're like just going to the US Supreme Court's docket, for whatever reason, they have this indexed on Taylor's first name, and her first name starts with an L. It's something like Lucille. So if you're searching the dockets, if you write Taylor, it doesn't come up in the search, but if you use her first name, Lucille, it will come up. I don't understand why that's true, but I've heard that from several people. The the plaintiffs in this case are literally asking the court to overrule Keller and Lathrop. And they're saying, they don't use exacting scrutiny, so they do not meet the court's current and sort of broad, already existing First Amendment law. They don't use the right test. And they make a big point of saying, listen, this case has an undisputed factual record, so we're the one, take our case. That case is fully briefed. If you go and look, all the briefs are there. It was initially scheduled for January 7th. It was on well, all of them were. And so all it says is rescheduled, and there's no date there. So I don't know when it will go to a conference date for a determination of whether the court will accept cert. And I don't know if the court will kind of wait till the other ones are fully briefed, the cert petitions being fully briefed, and try to decide them all together. Unclear. Okay, I'm done talking now.
I don't want to cut off the question period for this very enlightening, and thank you so very much for all this information. Right off this bat, does anybody have any questions they want to ask our general counsel? Governor Abell's got his hand up.
Thank you, Mr. President, and thank you, Julie, very much for that presentation. That was extremely helpful. And I want to echo the previous comments put out there to Chief Disciplinary Counsel Ende for his presentation. Those were both outstanding. Thank you both. Julie, I think one of the more interesting tasks we have in this process is looking at obviously the questions that the Chief Justice has posed to us about developments in recent case law, what may or may not be required. And one of the things that has happened in the last couple of years since the Bar Structure Work Group did its work was the addition of Justice Barrett on the U.S. Supreme Court. We now have a little bit of an indication of maybe what Justice Gorsuch is thinking. But to your knowledge, has Justice Barrett ever given us any indication about what her thoughts are about integrated bar associations or any of the trail of breadcrumbs from Keller to Janus to where we are now?
I'm not aware of anything about integrated bars. It might be that you could draw something about, her, the importance that she gives to individual rights and the First Amendment based on some of her other decisions. But I will say that I have not had a chance to actually go through and track all of her decisions on those issues.
Well, I will say, obviously, neither have I, but that might be something for us to kind of think about as we go about this. One of the significant sort of changes on the chessboard in the last couple of years. Thank you, Julie. And thank you, Mr. President.
Thank you. Thank you, President Towson. A couple of questions regarding the exacting scrutiny versus rational basis. Am I correct that Keller was a rational basis case or an exacting scrutiny case?
Yeah, good question. To my way of thinking, Keller doesn't really have First Amendment analysis that fits clearly into any specific bucket. It is now being referred to as rational basis. I don't know necessarily if you can pinpoint that on Keller, or if you can just say the court has over time really clarified and tightened up its decisions around that issue. And so, yeah, I think that's an interesting question. I also think it's an interesting question to look at the idea that, is it true that there's a different test for integrated bar associations than unions, mushrooms, any other compelled financial support for private speech. Like, is that, is there some reason that an integrated bar would use a different standard? Because that has been one of the issues, one of the threads in the cases. But yeah, I think it's a little hard to actually pinpoint.
And so one of our challenges is to predict what will happen with Keller. Because a lot of the circuits are saying Keller is still good law, and we're following, and so long as Keller's still good law, we still can have mandatory bars. But if Keller is overruled, is it most likely going to be overruled on the basis that it was a rational basis case and not an exacting scrutiny case?
You're asking me to predict the future, and I don't really know. And if Keller is overruled, I mean, is that is it clear that that would land in that there are no integrated bars? I don't know that. Keller could be reconsidered and overruled in a lot of different ways, right? It might. I don't really know the answer to that. I think that's something to look at. But Keller talks about what are the legitimate governmental interests that justify the compelled association. Well, maybe the court's going to look at those, right? Because those are different. There's no comparison between the compelling governmental interests in public sector unions and integrated bars. So I think that's a place that the court might look. I can't really give you an answer, but I certainly think all of the pieces of that analysis are places that you would want to look, and then really with an open mind consider all of the options, because I don't know necessarily that if Keller is reconsidered, that will end up, if they use exacting scrutiny, well, then we just have to, is that true? Is it true that an integrated bar is the least restrictive way to get to the compelling governmental interests, whatever those are determined to be? That could be difficult, and that is one of those questions that the Ninth Circuit put at the end of Crow, right? That the district court will have to answer. So, one thing about Crow, so Crow went back to the district court on remand, and that's where it is. And it's either in discovery still, or else the discovery period just ended recently and it's in kind of pretrial land. I'm not really sure, but I think, it's entirely possible that the district court will make some decision, and one of the two sides is going to send that back to the Ninth Circuit, and then it might go back up to the U.S. Supreme Court with a better established record. So that case could be back.
And that was going to be my next question, is that's one of the issues in the Crow case that they're deciding, exacting scrutiny.
Right. That was one of the questions is, is it exacting scrutiny, or is it this germaneness standard in Keller? Yeah.
Okay. Thank you.
Governor Stevens.
Okay. Julie, can you hear me?
Yes.
Okay. Well, you know that I've gone around and around about the whole notion of what is political, with little definition, which is problematic for me. But one of the questions I had, and you gave a couple of examples regarding, I think the Texas case, what would be in and what would be out. But I asked this question because so I'm talking about the Washington law against discrimination, a law that's been on our books predating Title VII and the Civil Rights Acts of 1964, I think 47. if someone were to drop a bill that basically said we are going to repeal the Washington law against discrimination, which changes the statutes of the state and changes the ability of lawyers to bring complaints regarding discrimination on various levels. Would speaking on that issue be in or out as relates to the analysis that you're looking at?
Yes, you're right. We've had this conversation several times. If you are using the Fifth Circuit's standard, I think it's out. And the reason I think it's out is because they are very much drawing the distinction, I believe, between a state discrimination law being part of the laws of the general laws of the state versus the bar association's role, which would be more limited than that and would be relating to the regulation of lawyers and and access. I think they termed it access to legal services. So, if there were a challenge to the ability of individuals to access lawyers or courts to challenge this change in the Washington law against discrimination, that might be closer to what the Fifth Circuit would see appropriately within its definition of germaneness. Yeah, there's something very difficult about this standard, I think, for a lot of people because you are tempted to say, listen, as a lawyer, I represent clients, and so it matters to me what the Washington law against discrimination says, because any change in that changes my ability to get relief for my clients. And that, I think, is the hard part, because if everything about what a lawyer uses to get relief for a client is in fact germane to bar associations' compelled fee activities, that's not much of a limitation. I think that's what the Fifth Circuit would decide. You are asking me to speculate, and I'm kind of making it up here, but that is my understanding of their decision.
Did you have a second question, Governor Stevens?
No, I'm going to leave it there.
Okay. It's 12:04, and I want everybody to hold your questions. We're actually ahead of schedule because General Counsel Shanklin was scheduled to give part 2 of her presentation after lunch. So what we'll do is we'll open it up for more questions for General Counsel Shanklin or anybody else who wants to chime in on this. And then we'll move on to the rest of our program. So lunch is here for those who are here at the bar offices. Let's reconvene at 1:05 p.m.